Welcome to BC Family Law Frequently Asked Questions with Kayla Doughton. Today I'm talking about grounds for divorce in Canada. What are the grounds for divorce? There is only one ground for divorce under Canadian law. The Canadian Divorce Act allows you or your ex to apply for a divorce on the grounds that there has been a breakdown in your marriage. There are exactly 3 ways that you can show the court that there's been a breakdown of your marriage. 1. That you've lived separate and apart from your spouse for at least 1 year. 2. That your spouse has committed adultery. And 3. That your spouse has abused you physically or mentally. In most cases, reaching settlement on related issues takes more than 1 year, and there is no reason to seek divorce on the basis that your spouse committed adultery or your spouse abused you physically or mentally. Instead, you can simply claim that you have lived separate and apart for at least 1 year. In Canada, divorce is awarded on a no-fault basis. This means that where the parties have lived separate and apart for 1 year, adultery and/or physical or mental cruelty is largely irrelevant. In BC, the courts have awarded costs against a party for insisting on lengthening a trial by calling evidence with respect to a claim for divorce on the basis of mental cruelty when the parties had already lived separate and apart for more than 1 year. Many family law cases are already very heated and difficult for those involved, and adding additional, unnecessary, and irrelevant inflammatory accusations only adds flame to the fire. In most cases, it is adequate to simply ask for a divorce on the basis that you and your spouse have lived separate and apart for 1 full year. In order to determine whether you and your ex have lived separate and apart for 1 full year, don't forget to check out my related video, What Does It Mean to Live Separate and Apart?